laws in Nigeria, which is the Constitution of the Federal Republic of Nigeria, 1999. These are the laws that guide, that regulate, that manage, that ensure proper implementation, proper procedures, proper process of arbitration in Nigeria. The Constitution, which is our ground norm, which is the foundation of our laws, guide every aspect, every processes of laws, including the arbitration law, because, for instance, the Constitution ensures the principle of fair hearing, the principle of fair hearing to ensure that uh, parties to arbitration are properly provided with notice, are given that right to fair hearing, right to communication, right to select uh, arbitrators of their own choice, right to select the proper venue, right to ensure that English is the language, or any other language that the parties understand with the support of interpreter. Then the Constitution too ensures that they have a recourse to review, the process, to agree or disagree with the award. And if all processes are followed, then everybody have a right to for implementation, as well as to enforce that award. But we call it implementation because it's not a judgment of court per se. But court can review arbitration award, and ensure that parties receive fair treatment and fair implementation of that award. That award is the final, will you call it, final decision of that arbitrators, or that arbitration panel. Thank you. Then drafting agreements. Can you hear me? Hello? Can you hear me?
Yes, we can hear you.
Okay. Drafting arbitration agreements means, Section 1 of the Arbitration and Conciliation Act states as follows: every arbitration agreement shall be in writing. Every arbitration agreement shall be in writing. So, when you go into agreement, most especially people that are doing project management, when people that are doing contract, people that are doing memorandum of understanding, people that are doing different forms of agreement, different forms of instruments, ensure that at the end, at the bottom, you have an arbitration included, arbitration clause. We can even have a separate arbitration agreement, which should be in writing, in a document signed by parties. Each person have to sign, ensure that signature is there. You sign your signature, you agree to do A, B, C, D. Then there have to be an exchange of letters, exchange of telex, or exchange of telegraph, or exchange of email, or exchange of WhatsApp communications. These are modern day communications which are recognized by law, or other forms of communication. In an exchange of point of claim and defense in which arbitration agreement is alleged by one party and not denied by another. Drafting agreement must have to contain an exchange of point of claims. That I'm claiming Mr. A is claiming so, and Mr. B is defending, dash, 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 and so on and so forth, in which arbitration agreement is alleged by one party and not denied by another. It has to be agreed by one party and it cannot be denied by another. So the agreement need to be very, very clear about this. Then example of arbitration clause that you need to put in an agreement. Arbitration, any dispute or claim arising out of or relating to this agreement. This is the arbitration clause that you need to put inside your agreement, so that you can have a valid claim. You can have the local standard. You can have the authority. You can have the power. You can have possible period of time. So you need to put this thing that you're seeing on the screen, you need to remove it and insert it into an agreement. There are different types, but this one is Can you hear me now?
Loud and clear.
Sorry, please. I don't know what happened. My village people are just attacking my internet. With all apologies and respect to my village people. So let me continue. Let me continue.
Okay, sir.
So once you see this clause I'm giving you, this is very, very important. This is very, very germane in arbitration. If you don't have this one, na oyo, serious one. If you don't have this one in your arbitration, it's very difficult to enforce that arbitration or to go to arbitration. You may end up going to court. So to avoid issues, any good lawyer, any sound lawyer will be able to put in this into your agreement. It states that any dispute or claim arising out of or relating to this agreement, including any question regarding its existence, validity, or termination of all the business's relationship created thereof, shall or less resolved by the parties within 14 days, unless if the issue in that agreement is resolved within 14 days. This agreement shall be referred to arbitration, be referred to and finally settled by arbitration in Nigeria. In Nigeria, if you put in London, then you need to go to London and do it. If you put in Ghana, you can decide to location of your arbitration, but it has its own implications and so on and so forth. You put in London, for instance, now you have to use an arbitrator in Nigeria and an arbitrator in London together. You know, with the appointment of 103, mostly is 1 is 2, 3 arbitrators by the president of the Nigerian Institute of Chartered Arbitrators. That's if you elect to use the arbitrator from the NICAP, like us now who are from the NICAP, under the Arbitration and Conciliation Act of 2004. The language of arbitration shall be English. You see this wording, they're very clear. They're very specific for a purpose. These are legal provisions. You know, these are guided by legal provision by the Conciliation and Arbitration and Conciliation Act 2004, Section 57. So am I clear?
Yes, sir.
Hello? All right, sir. So
Hello, sir.
element of arbitration. Yes, sir. I'm with you. So element of arbitration, choice of rules to follow. The rules that you're going to follow is very important in arbitration. What are the rules? What are the don'ts? What are the does? How can we be guided? Who do we select? Where do we do it? Where is the venue? You know? Then whether to use institutional or ad hoc arbitration. Do we use institutional or ad hoc arbitration? Then mode of appointment of arbitrators. How do we appoint them? You know, how do we choose them? How do we select them? How many of them do we want? Arbitrators, are they going to come from Nigeria? Are they going to come from abroad? Are the arbitrators based in Abuja or in Lagos or in Borno, you know, or in Enugu? If any special procedure rules will apply, ensure that are there any special procedure rules that will apply during this arbitration? Cost of arbitration. How do we bear the cost? Who will pay so percentage? Who will not pay so percentage? You know, does it come with certain vitiating elements in a contract? For example, factors that made the contracts make things goes wrong in a contract. So if it is my fault, am I the one that is going to bear the cost, the higher cost, maybe 60%? venue or place of arbitration. Is it going to be at the institute, a particular institute, you know? Is it going to be in an office? Is it going to be in a kind of official place? It depends on where people want it to be happen. You know, which dispute will be arbitrable? What are the disputes that can go to arbitration? Is it about the finance? Is it about the implementation of certain responsibility? Is it about services? Is it about construction? Is it about changing the mode of construction? Is it about the project management? You know, the cost, the type of project, you know? Is it about ensuring that even after building a particular structure, you know, the project managers will continue monitoring it, evaluation, you know, providing reviews, you know, turnaround maintenance, and so on and so forth. Will the award be subject to appeal? Can the people appeal the award? If, for instance, after the arbitration is concluded, after the process is concluded, can this appeal? Number of arbitrators to be appointed, you know, they have to decide. Should the arbitrator be neutral? Procedure to replace arbitrators upon non-performance. You can decide to say, these are arbitrators, they are not performing. No. You know, Mr. Mohammed Tukur as our arbitrator have not been performing. Maybe with his friend, Mr. Lawson, you know, or with Mr. Ibrahim, or Mr. Akinyemi as our arbitrators. They have not been performing, so let's replace them. Because of non-performance, you have a right as parties to arbitration. Refusal to act. If you refuse to act, you know, you have every right to say, okay, we're going to make some changes. Disability or death. When any of the parties, the arbitrators, have disability, physical disability, mental disability, you know, psychological disability, you know, injurious disability, trauma disability, you know, psychiatric disability. So the parties should be able to say, okay, we're changing. Or if there's the ultimate one, death. If the arbitrators dies or one of the arbitrators passed away, then the parties can decide to get a replacement. So powers of arbitrators, power to rule on jurisdiction. To happen in Kano or in of the Arbitration and Conciliation Act. Power to conduct proceedings. The arbitrators have a power to conduct proceedings, which is based on Section 20 of the same act. Power to act in case of a party's default. Sorry. Hello? Hello, colleagues, can you hear me?
Yes, I can hear you clearly.
Yes, you can.
Okay, thank you. So they have right to power to appoint expert, you know, power to order production of documents. The arbitrators can tell parties to bring documents. This power is given by the law. Power to appoint experts, you know, they can have the power to appoint experts, medical experts, what do you call it? Project management experts, engineering experts, architectural experts, accountants, chartered accountants, senior advocate of Nigeria, to come and support arbitration experts in different fields, different kind of experts from different field of endeavors, from different professions, from different consultants, consultancy levels or hierarchy, expert of different meds, different means, and different quality and hierarchy and grades. They have power to order disclosure of documents. They can say, okay, certain document is you can't hold a certain document. You can't hide the content of document. So you should have to disclose document. Then they have the power to inspect the subject matter of this. Mr. Abdurrahman, please can you mute yourself? Please can you mute yourself? Power to inspect the subject matter of disputes. You know, the arbitrators, they have the power to go and inspect the subject matter of it. You are doing a project as a project manager and this dispute arose, they can go and inspect. They go to the locus in code, we call it in law, locus in code, the location where the project is domicile, is situated, is located, the subject matter of the dispute. Power to decide procedural evidential matters. You can decide procedure, what are procedures to be done, what are the evidence to be done, to be used, or to be adduced, or to be submitted or implemented or accepted or denied. Power to make provisional orders. They can make temporary orders, they can make interim orders, and so on, but without abuse, without descending into the arena that much, without taking sides, without being partial or biased. They need to be neutral as much as possible. They need to be neutral. They need to be impartial. They need to be independent. They need to be sovereign. They need to ensure that they don't descend into favoring one party against the other. You know, then there is power to issue or to render, to issue or to correct an award. They can provide, they can correct an award, they can render or they can issue an award. That's the judgment. That's the final proclamation or the recommendation or the communique, as they say in some cycle. You know, the final decision. Then the power to order adjournments. They can be able to order adjournments. You know, change the adjournments. You know, what do you call it? To go on recess, to postpone with valid reason, without abuse of that authority or that responsibility or that sovereignty or that power. Power to order entry preservation of properties. They can ensure that properties are preserved so that somebody cannot move. You know, for instance, we are doing an arbitration on ownership of a private jet. Somebody will not take the private jet back to South Africa or back to the US, you know, until the process of arbitration is sorted out. They can give that internal preservation of that property. So, ladies and gentlemen, you need to be very much understanding of the process of arbitration and the power of the arbitrator. Let me talk about the power, the duty and responsibility of the parties as well. The parties to arbitration have duty to choose. They have the power to choose the arbitrators. You know, they can choose the arbitrators of their own choice. They have the power. You know, the parties to arbitration, they have the power to choose the venue, you know, or the location, you know, or the place of the arbitration. Then they have the right to fair hearing, you know, right to fair hearing, right to open and clear processes so that nothing is done in secret, nothing is concealed, you know, nothing is hidden from them. Then they have the party to change, you know, or to replace an arbitrator, you know. But these powers have certain limits, have certain exceptions. These are powers that should not be used arbitrarily, that should not be used flagrantly, that should not be used at the whims and caprices of the arbitrators, sorry, of the parties to arbitration. Are we together, please?
Yes, sir.
Please, if I'm too fast, or if I'm not very, or too slow, or I'm not clear, please, you're at liberty to draw my attention. You know, we're all. I'm a facilitator, but still I'm learning, and I'm subject to guidance as well as correction. You know, where necessary.
Don't
Then
worry,
again,
I'll understand.
all right. Thank you
No.
so much, sir. The
You're
parties
welcome.
they have a right to seek for appeal or right to seek for review, you know. But you know, don't forget that there are arbitration document. There are certain clauses in arbitration that said parties cannot appeal. The enforcement of the content or the award or the decision is final, so they cannot go on appeal. You know, if they agree during their agreement that there are foreclosures, then don't forget that parties have 14 days grace, but 14 days windows to go for administration, sorry, arbitration. So after that 14 days, if they don't resolve their issue, they can go for administration. They all have that arbitration. They all have that powers, and parties have a right to petition, you know, an arbitrator where the arbitrator does not do justice, where the arbitrator was not fair, where the administrator became corrupt, or he took their money, their resources, their funds, and they did not do their work. They have the power, they have the responsibility, they have the duty to go to the arbitrators institute to report to the arbitrator. If he's a lawyer, they have the right to go to the legal practitioners disciplinary committee to make a petition, or to the Nigerian Bar Association. They even have the right to file an action in court for recovery of resources, or recovery, or for compensation for damages and loss of time, you know, or causing them some kind of trauma by the arbitrators or by the arbitrator. Am I clear with this, please?
Very clear, sir.
All right. So may I stop at this point so that colleagues, so that our participants can review, ask any question, review their understanding of these processes based on what we have said, and any other question or clarification, or even guidance on what I have said, or any correction. Thank you.
Yes, participants, please, the floor is open for questions, contributions, and observations. Please, thank you. Please raise your hand by clicking the react button and picking the raise hand icon. Thank you. I think somebody asked a question earlier. I don't know if the person is still here. I think it was so that this is the time for that question to be analyzed, please. Please, can you repeat the question if you are here, sir?
So, hello? Hello?
Yes, hello.
We are here.
Okay. If in the absence of question or any clarification or review, so basically, I want us to understand that we all have maybe our employment, we have our businesses, we have our own career. So whenever we're going to do agreement, ensure you put arbitration clause. I beg. Please and please. This one will save you a lot of stress. This one will save you a lot of headache. So that ensure that when you do agreement, you put arbitration clause in the agreement. And arbitration mostly are covered by commercial transactions, not criminal. Criminal is mostly plea bargain. They call it plea bargain. If somebody chop money and EFCC arrest him, sometimes they do plea bargain so that the person will return substantial amount or the whole amount of money he has taken so that the charges against him can be dropped. Those are for criminal matters. Capital offenses, criminal offenses, mostly we don't do arbitration. Arbitration are for civil issues. You know, you were talking about issues of contract, issue of trade, issue of partnership, issue of goods and services, issue of project management. You're going to manage somebody's project, whether it's building project, whether it's road project, whether it's supermarket project, whether it's human HR project, human resources for an organization, whether it's managing of places of social gathering, hotel, and so on and so forth. These are commercial, these are civil matters, mostly arbitrations. Arbitration covers civil matters. Then again, try to understand that arbitration can be done. Different class of individuals need arbitration. Lawyers need arbitration, knowledge on arbitration. Engineers need knowledge of arbitration. We have members of Arbitration Institute who are doctors, who are lawyers, who are engineers, who are accountants, you know, who are business people, different strata of professions or career or vocations are open to becoming arbitrators. There are different institutes of arbitration in Nigeria. We have a lot of them here in Abuja that you will be able to join to become arbitrators. You know, they do it from membership from associates to members and to fellows. You go through certain processes by form. There are certain payments, training, and so on and so forth, which is very important for a lot of us to be able to have that certification, because they are highly recognized, they are highly valued, they are highly cherished, and it's good for our career development. Again, arbitration basically is a win-win situation for the parties. You know, it's not a partial process. It's a neutral process. Is a process that requires short time. Of course, patience should be part of the process. Patience should be a watchword. Then we need to ensure that we have agreed to go to arbitration. You know, even between landlord and tenant, there could be arbitration clause in the agreement. Then again, arbitration is an option to go into court. Everywhere people are practicing arbitration. I encourage us to be arbitrators because it's financially resources enriching, valuable. You know, arbitration is an ethical and respected career or calling. You know, and again, you could reach out to us or to Hajia, the registrar, for more guidance on how to become arbitrators. I remain available, I remain open, and I remain flexible to answer queries, to answer questions, to provide clarification and information that will ensure arbitrations you received are top-notch, professional and quality and efficient arbitration guidance and an instrument. Thank you very much. Let me not talk too much and take away our time. It's my pleasure. I'm so happy. I'm so honored. I'm privileged to provide this lecture. Sorry for talking too much. But we lawyers sometimes we are guilty of that. Thank you very much, and God bless you. Have the best. Have a good rest of the day. Thank you. I'm on standby in case of any last minute query, question, or clarification. God bless you.
Thank you.
Oh, thank you very much. Please, can you mute your microphone so that we can have one house? Okay. So thank you very much, Barrister Mohammed Kura. I would also like to let you know that Barrister Mohammed Kura is of the Nigerian Chartered Institute of Arbitrators. He's the secretary of the Abuja branch. At this point on our agenda, I think it's time to go for a short break, about 5 minutes break. Just stretch your legs, and then we come back to the one that is very, very critical to us as project managers. So somebody said there is a question on the chat. Okay. Yes, the PowerPoint presentation would be sent to your emails of the presentation done on the basics of arbitration by the last facilitator. So I'd like to say, let's just stretch around 5 minutes. Thank you very much. Hello, everyone. Hello, are we there?
Hello.
Okay, I think we've
Yes,
taken more
ma,
than
we're
5
here.
minutes.
Good morning. Yes,
Yes,
absolutely.
good morning again.
Yeah.
I
Yes,
think
we
we've
are.
taken more than 5 minutes. We've taken more than 5 minutes. So I think we will go back to the agenda, and we are on to the next session, which is a very, very important one for most of us as project managers. The next session is going to be taken by Mr. Tekenari Seki Lawansin, and the topic is arbitration in project execution. Thereafter, we will have questions and answers. Mr. Lawansin is the head of the Nigerian Chartered Institute of Arbitrators here in Abuja. So, sir, you have the floor. Thank you very much.
Thank you so much, madam. Good morning, good afternoon, good evening to everybody, wherever you're connecting. Am I audible enough, please? No?
Yes, we can hear you.
Okay, so I'll just go right into it.
But
Share my screen.
please, your son is too slow, sir. Can you?
Sorry, I didn't hear
Your
you.
voice is too slow.
Oh, okay. I'll be audible. I'll be more audible. Please, can you see my screen?
Yes,
Yes, we can.
we are
Okay.
seeing, sir.
Okay. Thank you so much once again. Thank you for the opportunity. I wish to respectfully acknowledge the leadership of Chartered Institute of Project Managers of Nigeria, the organizers of this very timely webinar, all professionals joining us from within and outside the Institute. I want to also particularly commend the Institute for commemorating World Social Justice Day through an engagement that speaks directly to professional responsibility and dispute resolution in project delivery. My name is Tekenari Seki Lawson. I'm a lawyer. I am the head of the Abuja office of the Nigerian Institute of Chartered Arbitrators. I've been invited to speak on arbitration in project execution. I consider this to be both a professional honor and intellectual duty. I'll say thank you once again. So without further ado, I'd like to go right into business of the day. Arbitration in project execution. So what are projects? Projects are society's instruments of progress. We have road construction, hospitals, digital infrastructure systems that project managers have to manage right from the inception, sometimes all the way through to even execution and all that. However, while projects are designed with precision, their execution is often characterized by uncertainty, competing interests, and contractual tension. So now the paradox here is that projects are meant to impose order, but they frequently generate disputes. That is quite ironical. The theme of this webinar is standard projects as a catalyst for renewed hope, and it suggests a collective aspiration for predictability, professionalism in project management. However, hope cannot survive where disputes are resolved through prolonged litigation, commercial hostility, and procedural paralysis. We have a situation where in our country today, you have projects that have been abandoned partly because oh, this issue is in court. We're trying to settle this problem in court and all that and all that. And we know how our litigation system in Nigeria can be. I'm a lawyer. I have a duty to represent the bar properly. So I'm not going to expose everything that happens in the bar, but I'm just going to speak on the surface to just let us know some of the issues we have and we suffer. Arbitration offers an alternative, even though I like to think that arbitration should be the mainstay. But at the moment, arbitration is an alternative to litigation. It's a mechanism that privileges expertise over theatrics. If you go to court today, you see lawyers shouting up and down, my lord, my lord, my lord, lawyers trying to prove to you that, oh, we know the law. If you bring this part of the law, we'll bring the other part of the law, and then we just stall the progress of whatever we have to do. It empowers efficiency over delay and resolution over rival. Over time, you see that when people go to court for litigation, once the matter is settled after a very long time, there is usually no camaraderie between the parties anymore. There's no friendship anymore between parties. You see parties that used to be friends before the issue arose. Once they go to court and come out, the friendship is over. But in arbitration, it's not like that. In arbitration, whilst we're trying to settle the issue, we're also trying to see how we can reconcile things. And we leave everybody happy. It's a win-win for everybody. So just look at it this way. Litigation disrupts project continuity. Arbitration promotes stability and professionalism. The collective aspiration we all have is professionalism, predictability, credibility in project delivery. The challenge, however, that we have, like I said before, is protracted litigation because you keep going back and forth, back and forth. I don't know if we have lawyers here or people who have been to court. Someone files a matter in court, and instead of just going straight to the point, the other person will come with a motion to do this, motion to do that. But meanwhile, the main issue has not been touched. But you will see that they've spent maybe 5 or 10 years just going about, what is it called? There's a matter of handling. I'm going to try as much as possible to give us real life experiences. There's a matter I was handling sometime in 2024. It's in Makurdi. And imagine the trip from Abuja to Makurdi every time that cost sits. And the cost of transporting me and lodging me in a hotel that the family had to bear every time the matter came up. Now, this matter was filed in 2008. But at 2024, I was still in court with the matter. When I went to court, the other lawyer would bring up one very frivolous motion. He would say, oh, my lord, this one. Oh, my lord, come on. And it just kept stalling the process. You can count it from 2008 to 2024. You see how long it has been. People would just think, oh, justice delayed is not justice denied. But I like to think that justice delayed is a lot of times justice denied. Let's come back to our issue. The alternative, like I said, is arbitration. Arbitration offers resolution over rival, offers efficiency over delay. Now, why project execution breeds disputes? Project execution is the stage at which contractual commitments are translated into physical or digital outputs. It entails deployment of labor, capital, materials, and managerial judgment in pursuit of defined objectives. Now, it is also the phase where contract clauses stop being abstract and start to produce consequences. Disputes during execution commonly arises from 5 key areas, and I'll just run through them. The first, we have delay and extension of time claims. You see that, well, as project managers, you know better than I do that time in projects is not just time, it is money, it's cost that is translated into days. So for instance, if you have to run a project for, say, 10 days, and you delay me beyond 10 days, you're actually cutting into my money. I'm sure you people know better than I do on that one. I'll give you an instance where I did a matter for someone. Okay, not necessarily a matter. Someone called me and said, oh, trying to build a website for my organization, and contacted a web designer. I don't know if I'm still audible, please.
Yes, you are.
Okay, thank you. So he told me, I contacted a web designer, and this is the contract he sent me. Please review as lawyer. I said, okay. And I looked at it, and quite frankly, lawyer, that contract looked so beautiful. The English was spot on. There was no problem. Everything was good. Now, in that contract, he said, I'm giving you 11 weeks to finish your project. In 11 weeks, I'll be done with your project. Mind you, there were also milestones for those projects. And then he says, if after 11 weeks I don't deliver the project, you can terminate the contract. If at every milestone, at every time frame for the milestone, I don't reach the milestone, you can terminate the project. Now, this was sometime in July last year. As of last week, we're still talking to the web designer. But now the issue is, because they didn't, what is it called? They didn't include the arbitration clause into the contract. We're still where we are. Even though I had advised, I said, look, put an arbitration clause here so that once this thing does not work according to the way you want it, you just go straight and collect your money. But they kept delaying that, and of course, I'm a lawyer. I won't impose my own decision on my client. So that's for time and delay and extension of time frame. The next, we have variation and scope changes. We know that every variation is a polite way of just admitting that the original plan was just optimistic. So we enter into a contract and I tell you, oh, and then this is how much I'm going to spend during this matter or during this thing. And then we see that 3 weeks into the contract for an 11-week contract, I'm already telling you, I'll need more money. Sometimes you can't blame them because we all live in a country where, what is it called? You go to the market today to buy a bottle of water for 100 naira. By evening, you go to buy that same bottle of water, the bill is 200 naira. So a lot of these things to also bring contractual disputes that arbitration that actually affect project execution. Sorry. The third is payment, certification, and cash disputes. Cash flow is the oxygen of contractors. If I starve you as a contractor of cash, that project will die. It's just common sense. If I don't give you money to perform the project, it's going to die. So I'm going to try as much as possible to be very quick. The fourth is quality and performance failures. Now, this is one of the most basic areas where disputes arise from project execution. You will see, oh, this is not what you told me you were going to do. A client once reached out to me and said, oh, look, I gave this guy money to paint my house. And this is like 6 months after, and he hasn't finished the painting. Now, even the one he has done in less than 2 weeks, once the rain came, it was already washing away and becoming faded. Those kind of things also bring contractual disputes in project execution. Finally, termination or suspension of work. This is where us as lawyers, or we as lawyers, this is where we jump in. Like once this one happens, we're ready, we'll tear our shirts and we'll just jump into the arena. This is what excites us as lawyers. When trust collapses, the law takes over. All these are issues that affect the execution of projects. There are common disputes that there are a lot of them, but these are common ones. Now, it is expedient to also inform you at this point. Sometimes these disputes don't just arise because the plan done before that. Sometimes they arise innocently. You go to the market, for instance, like I said earlier, you want to get something, and then you realize that what I charged this client was actually an old price. The price has changed. And then you come back to tell the client that, oh, look, this is what we are experiencing. The client tells you, oh, no, you can't tell me. And then you can't continue because you don't have the funds to continue. and then there's a dispute that arises and you're actually in court or before an arbiter. So it's important to know that these disputes are rarely out of malevolence or bad faith. They arise sometimes from ambiguity. Sometimes you see that, oh, the way the contract was drafted wasn't clear enough. Sometimes misaligned expectations, economic pressure, like I said, technical complexity, etc., etc. In effect, execution is where legal meets engineering reality. You know, reality is not always impressed by theory. It's not what you write in a book that happens all the time. So let's move over to the next slide. What is arbitration? Now, my big brother, my colleague, Mr. Toko, has done a perfect job. He has made mine very easy. Arbitration, according to Ronald Bernstein, in his Handbook of Arbitration Practice, he defined arbitration as an agreement of parties that a dispute between them be settled by a tribunal of their choice. Now, arbitration is a consensual dispute resolution process where parties agree to submit their dispute to a neutral third party whose decision is binding. Now, from these definitions, you see that some things are recorded. And what are they? Number one, arbitration is consensual. Now, you can't you must exchange the problem before it happens. You must know that, oh, I'm entering into a contract, there may be issues. Let me close that down. And then you decide to say, okay, in the event of a dispute, this is what is going to happen. We're going to submit to arbitration. Number one, it is consensual. Number two, parties agree to submit themselves to a third party. Number three, the outcome is binding. Now, what this means is, whilst it is consensual, the parties are the ones that are saying, okay, look, we're giving you, Oga, third party, we're giving you the right to, in the event of a dispute, we're giving you the right to make decisions over this dispute and settle us. Whatever you say as the neutral third party, that is going to be our final decision. It's just like parenting. For those of us that are parents, you know, you have two children that are fighting, and then they run and say, oh, mommy, or daddy, this is what A has done, this is what B has done. And then you sit as a neutral person, because you can't take sides. You sit as a neutral person, and then you make a decision. It's similar to what arbitration is. So the foundational distinction between litigation and arbitration is that once litigation derives its authority from the state, arbitration derives its own authority from the contract. The Constitution says, I'm so sorry, I'm a lawyer, I'm just going to be throwing some of these things. The Constitution says, I think in section 6, it says that, or it provides for courts and litigation generally, provides for what we call superior courts of record, the High Court, the Federal High Court, State High Court, National Industrial Court, Court of Appeal, Supreme Court, etc., etc. Now, arbitration itself is formed at the stage of the contract. The parties come together and say, look, we don't want to settle our issues in-house, we want to settle our issues ourselves. Now, arbitration is, like Mr. Tuko said earlier, arbitration is for civil commercial issues. You cannot go and arbitrate a murder case. Mr. A killed Mr. B. You can't say, oh, come, let's talk how we will settle it. Nah, that is a criminal matter and that goes to court. But for civil commercial cases, the best bet you can have is arbitration. I'll give you some instances or some reasons why arbitration is the best bet for commercial cases where project management falls. Number one, nobody wants to go to court to spend 10 years, 15 years, 20 years over a matter that can be sorted out in 2 months or in a month. Nobody wants to spend that long. Number two, nobody wants to tie their money down and be doing court matter, be paying lawyer, be going from one court to the other. Nobody wants to do that. So it is time conscious. Arbitration is time conscious as against litigation. I'm sorry to say, but the only time our courts are very fast in this country is when it has to do with political matters. Once it needs political matters, sorry, forget it. There's no speed in the judicial system. So nobody wants to go and spend all their time in court doing back and forth. So arbitration generally is law by agreement and not law by command as opposed to litigation. I hope I'm audible enough. So the defining attributes of arbitration, like I said, number one, you have party autonomy in procedural design. The parties decide. It is the parties that will say, look, this is what we want. This is how we want it to be. Number two, the neutrality of the adjudicator. The third party, whoever it is or whoever they are, must be neutral. Now, at this point, let me also make this point. Sometimes choosing an arbitrator or choosing arbitrators, the law allows for you to choose up to 3 arbitrators or 1 as case may be. Now, in the event where you have to choose 3 arbitrators, the what's his name? The claimant will bring his own arbitrator. He will go and source for his own. You, as the respondent, you will source for your own. And then both of you together will get an umpire who will be the third party, who will be the person to preside further arbitration. Now, that's where you have 3 arbitrators in the matter. But when you have 1 arbitrator, sometimes you can charge and say, okay, look, let's the Nigerian Institute of Chartered Arbitrators or whichever arbitration body, the Abuja Multi-Law Courthouse, or whatever, let this person be the one to pick our arbitrator for us. That's where, and I just thought to put that in as when it comes to neutrality of adjudicator. Also, we have confidentiality of proceedings. Now, this is one key factor in arbitration. As opposed to litigation where, what is it called? You have law reports that carry your matter. You have media that come and listen to what is happening. It's in the open. Whatever happens in litigation is in the open. Everybody can hear. Everybody can see. Oh, this person did this. This person stole my money. This person. Everybody in court will hear it. With litigation, with arbitration, sorry, it's not like that. With arbitration, there's confidentiality. All the parties, everything that has to do with the matter is just within the parties and the adjudicator. No other person hears it in. There's confidentiality, and I think this is the best part of it for commercial practitioners, because I don't want to take for instance P&ID case. I don't know how many of us followed that matter, but I'm also not going to give, I'm not going to delve into it because, again, confidentiality of proceedings. But just take, for instance, nobody heard about that matter until it was done. And even as it is done, we still do not have the fact. If you're not an insider, you will not know what happened. Exactly. You just have surface level facts, but you don't know everything that happened about it. Now, that's for confidentiality of proceedings. Flexibility of process. You know, you go to court, you see, before you come to court, you must file a writ of summons. When you file a writ of summons, before the defendant enters into the matter, he must file what we call a memorandum of appearance. There is laid down rules for litigation. And if you miss one, the matter will be thrown out of court. With arbitration, it's not like that. You know, there's flexibility of process. You know, it's not rigid as litigation. Then also the last one, we have finality of outcome. So once the award is given, it is final. Even courts will uphold it. Once the award is given by an arbitrator, it is final. The professional implication of this is the control shifts from institutions to parties. Instead of the court determining or deciding how the whole thing goes, it is parties who then decide how it goes. Procedure becomes a tool and not an obstacle. Like I said, you go to court, you see lawyers who file frivolous motions just to delay and just to stall proceedings because they don't have any defense sometimes. So, like I said, litigation is public, arbitration is private, litigation is formal, it's too formal. Arbitration is not like that, it's not that formal, it's not at all. Litigation is rigid. It doesn't shift. If he says put your left foot first before your right foot, if you put your right foot first, you have lost it. With arbitration, it's not like that. Litigation is adversarial. You go to court and you see how they shout at themselves. With arbitration, it's not like that, where it's resolution oriented. After everything, we want to see how we can bring parties together to still live in harmony, to still be able to do business with themselves, even though they have had issues before, you know. So litigation resembles the courtroom drama, typical, and then arbitration resembles a professionally moderated technical consultation. In other words, there's less theater and more substance. Now, arbitration clause. Our arbitration does not emerge spontaneously at the point of conflict. You know, a lot of people think, oh, it is when the problem comes that you will now begin to do, what's it called? You now go into arbitration. It's not always, it's not like that. In fact, it must be contractually meditated. I've said it before, that you must envisage the problem. You must envisage that, look, there may be issues somewhere along the line. So we need to close those loopholes. In the event of a dispute, this is what we're going to do. Now, that's what this is saying. Arbitration clauses constitute the gateway through which disputes exit the battlefield of execution and enter the forum of adjudication. Such clauses typically regulate the seat and venue of arbitration. I don't know if Mr. Toko actually talked about this, but let me just take a few moments to talk about seat and venue. Now, you look at some arbitration clauses and they tell you, oh, in the event of a dispute, parties will resolve to arbitration, blah, 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 blah. And then they come to this point and they say the seat of the arbitration shall be UK, London, UK. Now, a lot of times, even for lawyers too, this could be very tricky. A lot of lawyers make this mistake without realizing. You can, yes, arbitration is, what's the word now? Is across borders. You can actually arbitrate issues here in Nigeria that have to do with Singaporean companies or contracts and all that. However, the difficulty in this is, if, for instance, Mr. Tuku and Hajara, for instance, have a business together and they have a dispute, and the lawyer says, okay, for Mr. Tuku and Hajia, the seat of the arbitration shall be in the UK. Mind you, the contract was performed in Nigeria under Nigerian laws, and then you take the seat to the UK. What it means is you are taking the law that will govern that arbitration. You're moving it to the UK. Now, you don't necessarily have to take parties or conduct hearing in the UK. I don't know if I'm clear enough. You don't necessarily have to conduct the hearing in the UK. You can still conduct the hearing in Nigeria and still give the law to the UK. That's what a lot of lawyers do, and that's where they make the mistakes. We have a seat in Lagos. We have a seat of arbitration in Lagos. So we encourage our people, bring your arbitration matters under Nigerian law. And we understand that, yes, Nigerian law can sometimes be tricky, but our laws are not bad. We have good laws. Bring your arbitration to Nigerian laws and let us sort it out under Nigerian laws. So in a nutshell, the seat of arbitration has to do with the law that governs the arbitration, whilst the venue is just logistical. Where do you stay? For instance, Hajia could be in London at the moment, and then I'm in Nigeria, and we could just meet on Zoom like this, and we have our arbitration. But the seat of the arbitration could be in London or could be in China. I don't know if I'm clear. I hope I'm not confusing us. I hope I'm not confusing. If you have any questions on this, please just keep it. I'll love to talk about this later. Now, we also have governing procedural rules, number and qualifications of arbitrators, language of the proceedings. This also has to do with seats, sort of. A poorly drafted arbitration clause is akin to a faulty fire exit. It exists in theory. You only see, oh, there's a fire exit there, but there's no fire exit through. it is unhelpful during an emergency. Effective dispute management therefore begins at the drafting table, not the hearing room. Now, this is where you also need to have a good and a sound lawyer or a sound arbitrator or someone with good arbitration skills at this point, because you need someone who understands these things to draft your agreements for you. You know, a lot of times what people do is they just, oh, you're a lawyer, come and draft this thing for me, and that's fine. But some of us lawyers, what we do is just simply copy and paste, copy and paste, copy and paste. We already have a template for everything. We just copy paste without looking at the details, looking at the distinguishing fact between the template you have and the matter you have at hand. We just copy and paste. And then tomorrow, when there's an issue, you start seeing difficulty, you start seeing that even though there's a contract that will naturally free you of all forms of shackles, you'll still see that you're tied down to some level of difficulty because your lawyer did not do the due diligence it should have done. Now, functional relevance of arbitration to project execution. We have technical competence. Now, arbitrators may be selected for their expertise in construction, engineering, finance, or project management, and this mitigates the interpretive gap between legal doctrine and technical reality. Let me explain this. I'm going to explain this with an example. I did a matter sometime. Please just get me. I need us to be attentive to this point now. I did a matter in court one time. It had to do with, it was a criminal matter, and it had to do with rape. And we were defending, we were the defendants. I'm sorry, this is quite sensitive. I'm very sorry, but just for educational purposes, I think it's best we talk about it. It had to do with rape, and we were defendants. And the law is that whoever alleges must prove, and in criminal matters, we must prove beyond reasonable doubt. Now, they alleged that our client raped the girl. Whether he raped her or not, that's talk for another day. Our job was to say, okay, if you say he raped her, prove that he raped her. And the law is very clear on rape. For you to prove rape, you must, there are certain points you must prove. And the prosecution did not prove all of that. What they did was they just based their facts or they based their facts on hearsay without getting an expert. Now, in that kind of situation, you need a doctor's report to prove that there was rape, but there was no doctor's report. They just went on to talk about it, and that was how we were able to win that matter. Like I said, this is a very sensitive issue, and I'm sorry if it offends anybody. I just brought it up for educational purposes. Now, in arbitration, what arbitration offers that litigation doesn't offer is you as the technical or as the expert, you can be the arbitrator. You can be the one presenting your matter. Now, let's link it back to the litigation matter. Imagine if the lawyer who was giving this, who was prosecuting this rape case was a doctor. He would have done all the expert analysis for the court and said, my lord, this is how you prove it. This is what we did. This is what we did. But because he didn't do it, his matter failed on that premise. But now in arbitration, you as a project manager, you can be the one talking about presenting your matter in your arbitration case. You can be the one saying, oh, look, my lord, for the construction of a flyover, for instance, you must put the cement here, you must put the this here, you must put that here. And they didn't do it. And so they have lost it. Because you have the expertise, you can speak comfortably and authoritatively on the issue without necessarily getting an expert as a witness, as opposed to litigation where you have to get an expert to go into the witness box and testify. I don't know if I'm clear enough. Again, I would love to have questions. If you have questions, please just write them down. Also, the next one is temporal sensitivity. It's not merely money in projects. I said earlier that time is money, but it's not only money. Time is reputation. Time is opportunity. Time is contractual survival. arbitration offers relatively expedited procedures compared to judicial litigation. Time is reputation. Oh, like for instance, now the example I gave of my client trying to get someone to design a website for him in 11 weeks, and this is over 6 months, and we still have not gotten, the website has not been delivered to us. If tomorrow I want to develop a website, I can't meet that web designer because already his reputation is at risk because the time frame he gave to deliver is gone and he has not delivered the product. So it has affected his reputation, it has affected his opportunity with me and his contractual survival because you can wake up any day and say, okay, let's go to court. You get it. Now, confidentiality. Like I said, project disputes involve sensitive financial data. Sensitive financial data. We did an arbitration sometime in 2024. It was between a Singaporean, it was maritime, it was between a Singaporean company and a Nigerian maritime company. Because of confidentiality, I'm not going to say much. And you know, the details in that, the money that was at stake. When I saw it, I was like, oh wow, you know, I've never heard those kind of deals between private individuals, not government. Though. It has to do with money. I've never seen it before in my life. That's the first time I was seeing that much money in a transaction. So imagine if you had to go to court with those issues. You just put out your financial status to everybody. Everybody that comes to court knows that, okay, this is what these people are dragging. This is how much is involved. It also puts you at risk because you don't know who is in court, who's listening. Okay, so financial sensitive data are protected because of the confidentiality issue. Trade secrets, you know, sometimes you don't want people to know what you do to make yourself outstanding in business. But because there has been an issue that has to be arbitrated upon, you have to bring it out. You have to talk about it. It becomes a fact and issue. Once you are before an arbitration, you can rest assured and know that, okay, my trade secrets are still secrets. It's just between me, the what is it called, the respondent and the arbitrator. And I need to also put at this point that all parties to the arbitration are under obligation to maintain this confidentiality. So what it means is the arbitrator cannot tomorrow use that thing that he knows about you from your arbitration matter. It cannot use it against you because even courts will not accept this confidentiality clause in arbitration. Arbitration preserves commercial dignity in a way that public litigation does not. That's basically all I've been saying. Enforceability. Mr. Tuku said this. Arbitral awards benefit from international recognition regimes, facilitating cross-border enforcement. Now, the difference between arbitration and litigation in this point, if you have a court judgment, for instance, in Nigeria, before it can be enforced abroad, there will be plenty, what is it called? Plenty things to do, plenty conditions precedent before it can be enforced abroad, for instance. But with arbitration, no. Once there's an arbitral award in Nigeria, it is enforceable anywhere in the world. Anywhere in the world is enforceable. If you go to the UK, it's enforceable. If you go to China, you go to US, anywhere in the world, it's enforceable without stress, in fact. Procedural flexibility. Like I said earlier, arbitration permits bespoke procedures tailored to project complexity, unlike the rigid timetables which treat all disputes as equally impatient. You know, how do I explain this now? Like I said earlier, parties determine arbitration is party driven, and it's not as rigid and as difficult as litigation is. So please, am I still audible? I've been speaking. I don't know if I'm still audible. Hello? Hello?
Audible, yeah. Audible.
Okay. Thank you. I was worried
Alright.
for a moment. Thank you very much. Now, to the one that concerns all of us, project managers, district managers. I had said before that expertise as project managers is your best bet or is your selling point in arbitration. If you can come and say, okay, this is how this is done, this is how this is done, you handle your matter yourself. So you speak from the standpoint of authority, from the standpoint of expertise. That's one part. The modern project manager is no longer merely a scheduler of tasks or allocator of resources. He or she is an institutional gatekeeper of stability. Project managers influence arbitration by ensuring arbitration clauses are embedded in contracts. Mr. Toko said something before he rounded off. He said, always ensure that you have arbitration clauses embedded in your contract. There must be arbitration. We've gone past that time where it is optional. Right now, I advise if I have to draft a contract now, you must see arbitration clause. Must. Because number one, it saves you, well, we've said all that, it saves you a lot of stress. Now, number two, project managers influence arbitration by preserving documented evidence. You must also keep your evidence. If you want to go to arbitration, you not just go and produce evidence, you must keep documentary evidence. Identifying disputes before escalation, providing technical expertise to legal counsel. This goes back to talk about the expertise part I was talking about. Supporting implementation of arbitral outcomes. To paraphrase an old legal adage, says the best dispute is the one that never reaches arbitration. But the second best is the one that is arbitrated completely. So your best bet is to avoid disputes. But we know that human interaction is bereft with dispute, conflict. It's normal for human beings to have conflict. But that is where arbitration comes in. That's where arbitration comes in. You have to know that even though there is dispute, we must be able to settle it amicably. Not to settle it and then go our separate ways and lose our business relationship with each other. Arbitration and standardization in project management presupposes predictability, fairness, and replicability. Arbitration reinforces these values by institutionalizing dispute resolution. Now, you have to know that because there are disputes, you must institutionalize the resolution of those disputes. That's where arbitration comes in. You now know that, okay, yes, as disputes are coming in, we have an arbitration corner to handle this issue. You encouraging not merely a remedy for project failure, it is a preventive architecture for project success. So arbitration, just in a nutshell, ensures that a success in your project, even though you might be met with some disputes. Arbitration is there to help you sort out these disputes and to maintain the relationship with your partners. Limitations and structural challenges, of course, all over the world, existing, they say, whatever has an advantage has a disadvantage, even though I'm not going to talk about advantages. So they call it limitations. So, excuse me, limitations that can be overcome with time. Arbitration is not a panacea. Its effectiveness is constrained by strategic delay tactics. I had said earlier that litigation is where you find all the delays and everything. However, in some arbitration matters, you see some lawyers too that are still thinking that will come and want to, well, we didn't president and he said For every law you make in Nigeria, lawyers will always find a counter argument to it. So that's also goes a bit with arbitration. You also see some lawyers who try to throwing spanners into the wheel to just clog the whole thing. We have weak arbitration clauses. I'm going to dwell on this in a bit. You know, because, like I said earlier, because the practice now is copy and paste or ChatGPT. You just want to ChatGPT and type in, oh, give me an arbitration clause. And ChatGPT just gives them a very peripheral arbitration clause. They insert it into their contract, doing millions of dollars, not minding if that arbitration clause is watertight. Now, for your arbitration clause to succeed, your arbitration clause must, of course, refer to the arbitration. It must state the language of the arbitration. It must state the seat of the arbitration. It must state the appointing authority of the arbitrator. How is the arbitrator going to be appointed? Now, these 4 points must be there for your arbitration clause to succeed. But you find out that in some instances, people just copy and paste, especially in, I see mainly tenancy agreements. So I say that I just shake my head. Just say, oh, in the event of dispute, parties shall and move to the next clause. Who is going to arbitrate over the say? Who to appoint the arbitrator? They don't say. Where is the seat of the arbitrator? What is the language of the arbitration? They don't say. They just say that. Once that comes to arbitration, automatically collapses. So you that is thinking that, okay, you have an arbitration clause, so you're not going to spend your time in court, you find that you end up going to court because no arbitration clause as far as we're concerned, as far as the law is concerned. You just end up going back to litigation that you found out. So that's the way that's the limitation. So we need to inform ourselves as professionals that, okay, even if your lawyer doesn't know it, you as a professional who has gone through a big arbitration talk, you should be able to go to this and say, oh, this arbitration clause it's not going to stand. You should be able to tell that say teaching them their jobs, but you need to maintain your standard. Inadequate communication. Once you have inadequate communication, it's going to be a waste of time because there's no evidence you claims. You need to ensure communication is airtight. Limited arbitration literacy among professionals, generally among professionals, there's limited arbitration literacy. You find that for a lot of us, this is the first time hearing some things about this. Yes, arbitration is an English word, so a lot of us, all of us, know what arbitration means, but we don't know in depth what it entails. We don't know everything that has to be with arbitration, even though it concerns us. In fact, some of us are hearing today for the first time that arbitration actually concerns us because for a lot of us, we just go about our business. And well, some of us have been lucky. We've not had any disputes. We've not had any big issue that needs a third party to adjudicate over. So you've probably just been escaping. But I'm here to tell you that that problem, that dispute, can come up any day. I'm not praying for it. I'm not praying ill for anybody. But this is what, as lawyers, this is what we're taught to think. Envisage that problem will arise in the future and try to prevent it from affecting your deal, from affecting your business. So we need to keep talking to ourselves about arbitration literacy. We need to keep educating ourselves so that we know that, okay, yes, for every business deal we have, in your capacity as a project manager, in your personal capacity, you must ensure that whatever commercial transaction you have is a written arbitration clause that protects you from loss. We need to ensure that. So we cannot overemphasize this issue, we need to always talk to ourselves about this. And I commend the Institute for this very time, like I said initially, for this very timely webinar, for this very timely occasion. I would suggest, this is my suggestion, I would suggest that time and time again, once in a while, these kinds of webinars are put together to educate us, get some more experts on the field to talk to us about this thing. If possible, we'll also have physical meets, but that's what's it called? That's talk for another day. So we need to always ensure that there's literacy among project professionals. These challenges necessitate institutional arbitration frameworks, early dispute resolution protocols, capacity building for project managers, improved contractual drafting. Even the most elegant dispute mechanism falters when fed poor records and those clauses, much like a court that is asked to adjudicate on a contract that's written in poetic metaphor. You see this poetic metaphor of contracts, I've seen a lot of them. And sometimes you go to court and you just know that this guy is just going to waste his time in court. Because what is this now that you call a contract? Your contract is neither here nor there. It's just there because, well, let it be that there's a contract. It doesn't state anything. It doesn't protect anybody. It doesn't prevent anything. It's just there because, okay, it's just, for some people, it's just proof that we entered into a contract. And that's not what contracts should be. It has to protect you too. It has to be a shield for you that's entering into the contract. So arbitration helps with all of that. Arbitration as a catalyst to renewed hope. We're bringing it home. Arbitration expands access to justice by offering a faster, less procedurally burdensome forum for dispute resolution. We can't, that's basically all I've been saying, and that's basically all Mr. Tuko has said. Faster access to justice, speedy access to justice. It eases judicial congestion. You go to court today. In the Supreme Court, I'll tell you one that just happened to us sometime. This is March, this is February. I think sometime towards the end of last year. We were to get a date in the Supreme Court, and we went to the court, and they are adjourning a 2025 matter to 2027 November. You can imagine you have the whole of 2026 gone. You will not hear that matter. The whole of, in fact, that 2027, we were lucky to get that 2027 because the Supreme Court's diary as of today is congested up to 2028, 2029. You can find this out for yourself. You can just inquire from lawyers who have dealings in the Supreme Court. I will tell you, the diary is clogged. We have just 21 justices of the Supreme Court. I don't even think they're up to 21 now. Just 21 of them, and they hear matters from all over the country. Every kind of matter is before them. So imagine if you have that kind of situation. You have it in the High Court, you have it in the Industrial Court, you have it in the Court of Appeal, the same situation. So imagine how congested the court dockets are. So it's in your best interest as a professional to know that, okay, look, we need to go or toe the way of arbitration. I'm almost done, please. I feel like I've been talking for too long. Arbitration also rebuilds investor confidence because you are sure it is predictable, you are sure of the neutrality, and you are sure of the enforceability of outcomes. I'll tell you another thing. Again, the NBA president was telling us the other day, he said, these days now, you can't predict the Nigerian laws anymore. You cannot predict. In law, we have what we call judicial precedents. What it means is if a superior court has given judgment on a matter before, every other matter that has to do with the same subject matter or the same topic, every other court that is below that court must follow the decision of that court. I don't know if I'm clear enough. So if the Supreme Court says, for instance, in political issues now, party matters are non-justiciable, every court below the Supreme Court, once that kind of issue comes up, they will uphold the decision of the Supreme Court. But today, you can't predict it again because you go to court and the Supreme Court that said A yesterday, when you come today, they'll tell you B. You come tomorrow, they'll tell you C. So you even as lawyers, you can't predict it again. We don't know what 5 cases and we're not sure of the cases anymore because you can go to court and you will see surprises. But with arbitration, no, it's not like that. You are sure that, look, this is the decision that is going to be reached because you can put 1 and 2 together. You are sure that the arbiter is neutral and you're sure that your outcome or your award is enforced. Also, arbitration strengthens contractual certainty by ensuring that arbitration not be aspirational, but they are enforceable. Arbitration promotes professional ethics and discipline by subjecting disputes to expert adjudication, bringing industry standards, like I said before. You know that to build a firewall, how to make 10 bags of cement, for instance. Then someone is building a firewall with 3 bags of cement. Once it comes before an arbitration panel, the standards are there. Experts are there to say, oh, yes, you need 10 bags, you can't use 3 bags. So that's just an example of what I'm trying to say. It promotes professional ethics and discipline. In conclusion, arbitration occupies a strategic intersection between law and project management. It converts conflict into procedure and uncertainty into resolution. When integrated into project execution frameworks, arbitration fosters stability, accountability, and professional maturity. In an era seeking renewed hope to standard projects, arbitration functions as both guardian and guarantor of contractual trust. It ensures that disputes do not become derailments and that execution remains aligned with expectation. In short, arbitration is not the enemy of project execution, it is its safety net. End here, but before I end here, I have some practical advice I'm going to give to us as project managers. I'm going to be speaking to you now as a professional, as a lawyer and an arbitrator. Number 1, like Mr. Tuko has said, please ensure that you have arbitration clauses inserted in every contract you draft or you enter into. If someone brings a contract and says sign, please look for the arbitration clause. If there's no arbitration clause, please tell them to take it back, insert an arbitration clause that has all the metrics of a proper arbitration clause. That's 1. Your arbitration clauses must be drafted clearly. That's 2. Number 3, manage variations formally. That's 3. Number 4, keep proper records. We cannot overemphasize this point. You must keep proper records. Keep proper meticulous records. The next one, treat disputes early. Don't try to manage them until they blow up in your face. Once disputes come up, face them head on, and then face them timely. Next one, separate technical agreements from personal ego. The human beings, man naturally has ego. We still think animals, like some philosophers will say. But you need to separate technical disagreements from personal or emotional ego. Most disputes are not technical, they are emotional with invoices attached. I've been in that kind of situation where this dispute is not supposed to be there. But because, oh no, you want to take me for a ride, you know that kind of feeling. We then bring up disputes from where there are no disputes. We need to separate, we need to draw the line in all of these things. Standard projects require standard dispute mechanisms. When disputes are inevitable, resolution must be intelligent. Arbitration is not an escape from law. No. Don't think that because you're not going to do all the litigation and you're running away from the law. You are not. Arbitration is hinged on the law. It is law that is adapted to project reality. So I'd like to thank you all for your attention. Once again, I'd like to thank the Chartered Institute of Project Managers of Nigeria for this platform. I thank all of you that participated for your professional engagement. I expect some more engagement after this. I look forward to future deliberations, future, what's the word now? Future engagements with you all. Thank you so much. But before I do again, sorry, I'd like to make a call for during the introduction, the registrar introduced me as the Abuja office of NICA. And I think it would be unfair to my employer if at this platform I speak about what we do. Now, I'm going to call for membership. Please mind you, becoming a member of NICA does not in any way preclude you from your obligations to the Chartered Institute of Project Managers. No, you can be a member of both bodies and still function effectively. In fact, I believe that it is best for you if you are a member of an arbitration body. For those who are interested in deepening their competence in arbitration and alternative dispute resolution, I would strongly recommend NICA, Nigerian Institute of Chartered Arbitrators. NICA is Nigeria's foremost professional body, and we're dedicated to the training, certification, and regulation of arbitrators and ADR practitioners all over the country. It is the institutional bridge between legal theory and dispute resolution practice. Sorry, excuse me. Membership of NICA is not just decorative, it's not fancy. It is developmental. It provides structured training, recognized professional qualifications, exposure to practice, and access to a network of professionals across law, engineering, construction, finance, and project management. In a world where disputes are inevitable, competence in their resolution is no longer optional, it's strategic. For project managers, NICA offers tools to manage conflict intelligently. For lawyers, it offers relevance beyond just litigation. For professionals, generally, what we do is we offer credibility now in dispute resolution in a dispute-driven economy. So if arbitration is something that you wish to understand, if it's something you wish to practice, or it's something you wish to specialize in, NICAB is not a bad place to begin. NICAB is where you should begin. NICAB is certainly not a bad place to belong. NICAB is where you should belong. So I encourage all of you who are interested. I hope that everyone is interested in becoming a member. I encourage all of you to explore NICAB's membership, take advantage of our training programs, professional community. We're all across the country. If you need more details, you can meet the registrar of your institute. She has she get close to us, and we'll be glad to speak to you. Mind you, also, this is my last point. Becoming an arbitrator has absolutely nothing to do with your profession. You don't need to be a lawyer to become an arbitrator. These days, you see, the other day we were in Benue, market women are also joining this thing because problem is not for lawyers alone, it's for everybody. So it's high time to reason like that, see how we can solve our issues without necessarily going to court to waste our time. Thank you so much. Thank you very much for this opportunity. I very to speak to you. Thank you very much.
Thank you very much, our facilitator, Mr. Lawson. We really appreciate your very educative and enlightening presentation regarding project management and arbitration. Like we said in the beginning, our able board member stated, North Central Zone representative stated, arbitration is inevitable in the new world of project management. Project management is very critical, like you said, in the commercial, it's at the core of all commercial engagements. So we'll say thank you very much for that presentation. And I want you to be rest assured that this is the beginning of better collaborations between the Chartered Institute of Project Managers of Nigeria and your very chartered Institute of Arbitrators. I would also like to say a very big thank you to the last facilitator, Mohamed Tukur. However, at this point, I think the next topic is a closing remark by one of our council members in the person of Barrister Yusuf Abdelkader, who is also our zonal coordinator for North West. Sir, you have the floor.
Good afternoon, everybody. Can you hear me? Can you hear me?
Yes, we can.
Yes, we do.
Good afternoon, everyone. I must sincerely thank. Can you hear me? Hello?
Yes, we can hear you. Yes, we can hear you.
I must sincerely thank the organizers of this very important webinar, even though we quite had some challenges of network and other things. And like at the beginning of this program, the Hajia Fatima has clearly summarized and gave the objectives of this webinar. And I'm happy to see my colleagues, Mr. Tukur and Mr. Seki Tekinari Lawson. They have done a very wonderful presentation, very intensive and very quite enlightening. And it has given us the background of the challenges ahead we are going to be facing in the course of our professional callings. Well, before the closing remarks, I would like to add one or two things that may be beneficial to our colleagues who are the members of the CIPM. The first question you will ask yourself is, let me approach it in two ways. I work in government for over 27 years, and I know the importance of arbitration and conciliation. However, the first question you will ask yourself, who is your client? If you are dealing with the government, you don't have much problem when it comes to arbitration, because there is no agreement government will enter into without compliance with the Administration and Conciliation Act, as mentioned earlier. Where you will have a challenge is when you are an individual. An individual means you have a land to buy, you have a contract. Is this marriage? Is this business within and outside the country? What are the basic things that I need to put in my place? And most of the speakers have clearly summarized the basics, because when you have the basics as you are at your fingertips, anywhere you go, you would think that, okay, yes, before I enter into any agreement as a professional, as an individual, as a family member, as head of community, really, I need arbitration clause to be inserted in whatever I do. Kindly recall that most of the discussions they had, the lawyers, they kept on emphasizing on the word shall. For a lawyer, once you hear shall, that means you don't have a choice. It's compulsory, you must comply. And failure to comply, the consequences, you'll be the one to be blamed. So when the law says shall, meaning that you don't have a choice. If it is government who is your client, I know when I was in the Federal Ministry of Justice, there is a department clearly depending on the threshold of the contract you want to enter into. They must vet that agreement and ensure that arbitration clause is put in place. So this one is something that we take home and do everything. Then the second issue is we are talking from the beginning of the program, we said we want to make sure that we pass out quacks among the CIPM members and other professional bodies. These quacks, if you don't follow the rules as laid down by the law and procedure, definitely when you go and enter into an agreement and then the consequences doesn't favor you, you'll be the one to blame yourself. Like for lawyers, even if you are a lawyer, if you abuse a process, like one of the speakers said, Even a lawyer, when he goofed, when he didn't follow the rules and regulations, you can have a right to write a petition. We have a committee we call Legal Practitioner Disciplinary Committee. And if I happen to misbehave, that Legal Practitioner Disciplinary Committee can be a way you can even punish me. In fact, they can take away my wig and gowns, and I cannot practice. I can be bad. So you can see the extent even lawyers are not exempted. Even medical doctors are not exempted. Talk less of CIPM members who are professionals. Now, whatever we do, you can recall recently, it wasn't 2 years or 3 years back, we had an issue, even Nigeria had issue, and when you remember the case of P&D, when we had the controversial contract that was entered, even though because the government took its own position, we couldn't have been out of that quagmire. And for your information, the Administration and Conciliation Act they are talking about, this is to do with international commercial arbitration outside Nigeria, then interstate between federal government and states, and then apart from interstate, even within ourselves, and that is the bottom line. Now, somebody fundamentally raised an issue. He said, what are the checklists? When you're talking about the checklist, I'm sure the registrar was trying to emphasize this is the best way or the best time we look at our checklist. And you cannot develop a checklist without carrying Bureau of Public Procurements along. Because most of these projects we are talking about from the government side, you must go and get clearance when it comes to bidding. How do you bid? What are the clauses? What are the checklists you are going to put in the agreement? Once you put your own quotations and you do not qualify to have those checklists, it's going to be an issue. So I'm appealing and advising, since this is the beginning, we can on our own through different, because when you look at the CIPI Act, it talks about designing and implementing structured curriculum, education, training, and the rest. Maybe in the course of subsequent programs, which may be physical, we'll be able to have to be on one page so that anybody who when a CPIM developed its own checklist, that means the moment you go and you want to do an agreement, you want to be a certified manager for a project, you know what are the checklists that are available, and then life and law is dynamic. It doesn't like my colleague said when he was talking about the Supreme Court, you don't know the judicial precedent. The judicial precedent always keep on changing. Likewise, the CIPIM project managers will have to keep on developing in this era of technology, and so that we know we're on the same page. Let me give you, in conclusion, one example. Most of our National Assembly members and most of our government representatives, even Mr. President, His Excellency, when they go outside the country to sign agreement, instruments, protocols, and what have you, at the end of the day, when they come back, for them to be sure of what they are doing, Section 12 of the 1999 Constitution as amended make it a duty that whatever agreement you sign outside, whether protocol must be domesticated in Nigeria, and Section 12 is very clear. That means the National Assembly must domesticate those kind of agreements, talk less of an individual like me and you. So having said that, this is a very good day, and I don't want us to go beyond what we are looking at. It's a very excellent presentation, very excellent participation, and for our coordinators and our board members. And I'm happy, most of the professionals I saw online, those from Ilorin, those from Port Harcourt, those from Lagos, from Kano and other Kaduna, is a very quite interesting. You are respected personalities. We can't joke. God bless everybody, and I can assure you this is the beginning. And since it has been emphasized, arbitration and conciliation is very important. So anytime we have any dispute, even among ourselves, the best option is let us ensure that we have arbitration to settle it. If we cannot settle it, then the last resort is to go to court. And I can assure you that one, fundamentally, we comply with what is in place. The sky is our limit, and we're going to do very good things. And we have a duty. We have a duty. When we started the program, apart from opening prayer, we are talking about national anthem. Then what are our roles to support federal government? We must support federal government, because when you look at the act establishes CIPMN, it was a law processed or supported or procured by the federal government itself. It's an agency. So you are welcome on board, and God bless everyone. And I'm happy to be part of you. And I pray we'll keep on working and having same collaboration. And I congratulate the Registrar General of the membership of this organ for this important initiative. And God will help us to carry on. I thank you, and I wish everybody's, those who are fasting, all of us are fasting, depending on the faith. And then we need good prayers for this association, and then we need good prayer for our country. God bless everybody. Thank you for listening, and bye for now.
Thank you very much, sir, our able board member. We really appreciate your speech. At this point, I think it is a wrap for this particular event, and I don't have much to add. My board member has already stated, giving all the vote of thanks. So the last agenda is prayers, and just like we started, I think I will implore each and every one of us to pray in his own particular faith. Thank you very much.
Hello, ma.
Yeah.
Yeah, sorry, before we go, I don't know if anybody has any question. I know that the board member has, what the board member has said, as I practically summarized all that we've said and answered a lot of questions. But I don't know if anybody has any questions that they would just like to throw out that they'll need more clarity on.
Well, I can see that most of the participants have logged off, but I want to assure you that this is just the beginning of our series. We're going to come on a courtesy call to you, and we'll sit down and iron out areas, because if we're handling projects, I think that we will prefer the option of arbitration as against litigation. So I think you should look out to see us soon, and more professional, educative forum between us and you people.
Okay, thank you so much. Thank you very much, ma'am.
You are most welcome, sir. You are most welcome, sir. So in the event of that, I think it's a wrap. Thank you very much for all our participants. Some of your certificates have been sent to you. Some of your email addresses, they have some issues. You expect to see some of your certificates on your WhatsApp accounts. And also you will get slides of Barrister Tukur, who carried the last topic, and also the one presented right now by Barrister Lawson. So thank you very much, and I will say bye-bye. Thank you.
Thank you.
Thank you.